All right, well, welcome everyone. Good morning. So our first panel this morning is going to provide an update on federal enforcement actions with respect to wildlife. So our first speakers together, Alex Bernard and Aaron Ecott. So Alex is a senior counsel with the Public Prosecution Service of Canada's Regulatory and Economic Crime Team in Edmonton. Albert joined that group, and he joined that group in 2009. He has conducted a variety of prosecutions for offenses related to pollution, wildlife conservation, and trafficking. Prior to 2009, Alex was counsel with Justice Canada's regional office in the Northwest Territories, where he provided litigation and advisory services on matters involving environmental regulation and environmental assessment, including acting as one of Government of Canada's counsel on the Joint Review Panel for the Mackenzie Gas Project. Aaron Ecott is a prosecutor with the Public Prosecution Service of Canada up in Edmonton as well. She has an LLB from Dalhousie Schulich School of Law with a specialization in environmental law. She's prosecuted federal regulatory offenses since 2002 with a focus on environmental offenses. She practices primarily in Alberta but has worked on environmental prosecutions in several provinces and territories. And in addition to her work as a prosecutor, she also teaches environmental law at the University of Alberta. And then finally, we also have Kevin Butterfield. And I guess, Kevin, I don't know if you want to come on down now, and you can just share the hot seat, as it were. Kevin's been with Environment Canada for 32 years, working both in science and law enforcement. He holds a technical diploma in resource sciences and a degree in atmospheric science. He has both police and meteorological experience prior to joining the enforcement program with Environment Canada in the 1990s. He's worked as a field officer conducting inspections and investigations in Alberta, has spent 3 years as a national coordinator of investigations for the Environmental Protection Service in Ottawa, and 5 years as the regional manager of investigations in Atlantic Canada. In 2009, he assumed the role of regional director for the Wildlife Enforcement Director in Edmonton, where he's responsible for overseeing federal wildlife enforcement within 3 provinces and 2 territories. So we're going to begin with Alex and Aaron, and you have your PowerPoint here. Yep. So we'll just go and let's see if this. So I would suggest that you just stick with the keyboard.
Stick with the keyboard, not with that?
Yeah.
All right, so that means I have to stand up here, which is fine.
Yeah.
Sorry, Alex. I can always stand here while you talk. Alex likes to sit while he talks. I like to stand while I talk. So.
I'm a rover. If I stand, I can just start moving around.
Yeah, he uses that as an intimidation tactic when he's cross-examining witnesses. So. As you heard, both Alex and I work for the Public Prosecution Service of Canada, and we do regulatory prosecutions, and we both do prosecutions, thank you, related to wildlife protection. This morning together, we're going to take turns. We're going to give you a bit of a primer on federal offenses that involve wildlife protection. And a few cases, a little bit of a case update. After that, Kevin's going to take over and talk to you about wildlife trafficking, including international aspects of wildlife trafficking. Let me see if I can make this work. This is our little disclaimer that we're required to put up here. These views are Alex and my views and not the views of the Public Prosecution Service of Canada. Doing my legal due diligence. There's 5 acts that, as prosecutors, we see most frequently that deal with protection of wildlife. The government has several acts overall that protect wildlife, but these are the 5 that we see most frequently. We're going to look at the first 4 of them in detail. I don't think we're going to have time to get to the Canada National Parks Act, which is the last one. But it includes lots of offenses for hunting, possessing, trafficking wild animals, as well as animal derivatives. And it also includes offenses for harming, possessing, and trafficking plants that are taken from the parks. There are additional pieces of federal environmental legislation on top of these 5. They protect the environment more generally. They're not focused specifically on wildlife protection, but because they're focused on the environment generally, they are going to have an impact on the protection of wildlife. And so some of those you will have heard of before. They're the Canadian Environmental Protection Act, the Canada Shipping Act, for instance, and another one would be the Arctic Waters Pollution Prevention Act. But these are the first 4 anyways. WAPREDA, which you can read up there, is the Wild Animal and Plant Protection and Regulation of International and Interprovincial Trade Act. I will never use the title. I will always use WAPREDA. There's the Migratory Birds Convention Act, the Species at Risk Act, and then the Fisheries Act. So almost all federal offenses to protect wildlife are strict liability offenses. And this means that we have to, as prosecutors, prove the actus reus, so we have to prove the offending action, but we don't have to prove the mens rea. We don't have to prove that there was intent by the offender to do the bad act. We just have to prove they did the bad act. So that's a little bit easier than normal criminal offenses where you have to prove the bad act and the intention to do the bad act. And then there are a few defenses to strict liability offenses, and the 2 key ones are due diligence. So due diligence basically means the offender took all reasonable measures or all reasonable care to try and not commit the offense, to not do the bad act. So if the court finds that the accused is duly diligent, then the prosecution will not be successful. And another defense that we sometimes see is officially induced error. And basically what this means is that when the offense was committed, the offender reasonably relied on some sort of erroneous advice that they had received from a government official who's responsible for the particular legislation that they offended. So some officer or some other government official responsible for the legislation gave some advice to the offender, and the offender relied on that advice when they committed the offense. And I'm just going to skip straight to the heart of everything for me anyway. And that's sentencing. What do we get when we have an offense? And we'll look at the offenses more specifically, but if someone is convicted for an offense, what is the penalty? What's the sentence going to be? So over the last few years, federal fines under federal environmental legislation have increased significantly. So it used to be that most federal environmental offenses had a maximum fine of $300,000 on a summary offense, and a maximum fine of $1 million on an indictable offense, the indictable being more serious than the summary offenses. There was no minimum fine under the old legislative schemes. But in the last several years, that has changed. A lot of federal environmental legislation has been amended. Now we are seeing minimum and maximum fines that are separated. So there's a separate minimum and maximum fine for individuals, a minimum and maximum fine for basically large corporations, anything that is over 5 million annual gross revenue, and then a minimum and maximum for small revenue corporations. And these fines, as you can see, are set out in this chart. So on summary conviction for an individual, your minimum is now $5,000, your max is $300,000. Large corporation, your minimum is $100,000 and your maximum is $4 million. On a small revenue on the summary offense, your minimum is $25,000 and your maximum is $2 million. And then on the next call or next row, you'll see the indictable maximums and minimums for an individual, $15,000 minimum and maximum $1 million. For a large corporation, the minimum is $500,000 and maximum $6 million. And for a small revenue corporation on an indictable offense, your minimum is $75,000 and maximum $4 million. What's interesting about this is these minimum and maximums double if it's the offender's subsequent offense. So you can see this is much more significant than our old regime of the $300,000 and the $1 million. There's also a provision in all of the legislation that allows the courts to go below the minimum fine if the offender can prove that that minimum fine would be undue hardship. But they have to prove that. There are some exceptions to that fine scheme that I just spoke to you about, and one of them is the Species at Risk Act. So the Species at Risk Act sort of separates the fine provisions a little bit differently. There's a maximum fine for a person or a nonprofit organization, and that's a summary maximum fine of $50,000 and indictable of $250,000. And then for a corporation, and it doesn't matter what size the corporation is, there's a summary $300,000 maximum fine and then an indictable $1 million maximum fine. This Species at Risk Act hasn't had its fine provisions amended as recently as the other legislation has. The Canada National Parks Act has those same much higher maximum fines that we saw in the previous slide, but it also has, it's got quite a scheme for other types of penalties depending on the offense, and those penalties are lower. One important thing to note is that where an offense involves more than one day, or more than one animal, or more than one plant, then it's considered to be a separate offense for each day, each animal, and each plant for the purposes of the minimum and maximum, which means if you have 5 caribou, for instance, that are impacted by the offense, technically that minimum and maximum is times 5 for each of those 5 caribou. So you can see how this can create much higher penalties than the slide we first looked at. Except for the Species at Risk Act, all fines now automatically go to the Environmental Damages Fund. So fines generally under other offenses just go into the Government of Canada's general revenue to be used however the Government of Canada wants to use it. But under the Environmental Damages Fund, the monies are used for environmental conservation, research, and education. And this was a fund that's administered by Environment and Climate Change Canada. And it was created in about the mid-1990s by the federal government specifically for the purpose of court-ordered monies. And that fund, as you can tell, is growing significantly now with larger fines. One thing I wanted to note is that some of the federal environmental legislation now makes reference to use and non-use value of the environment. And this is used for the purposes of sentencing. So basically what it means is there's an expert who can assess what the economic value of the damaged environment is, or the economic value of the particular wildlife species that was harmed. And we do need an expert who can do this, and I'm learning there's more and more of them in Canada than I ever knew. And the assessment is based on both the use and the non-use value of that damaged wildlife or damaged environment. So use value is described or defined as the value of the environment for people who use it, so for people who like to fish or canoe or hike. And then non-use value is basically the value of the undamaged environment. It's kind of like environment for environment's sake. It doesn't necessarily have to be used for anything. And these use and non-use values can be used to help assess what an appropriate fine would be in a particular case. If the value of the use or non-use is quite high, that's an aggravating factor, and it supports a higher fine. Those values can also be used to help support what would be appropriate remediation for a particular environment or species. And the last thing that I was going to talk about with respect to sentences is the ability under the federal environmental legislation for courts to order creative sentences. There's really broad provisions under of all federal environmental legislation for courts to order all sorts of creative things. So some of them are listed here, but I can't remember. I think it might be the Migratory Birds Convention Act where it goes through subsection the alphabet like almost twice for all the different types of creative sentences that can be ordered. The first one here is that the court can order an additional penalty for any money that an offender made or saved as a result of the offense. This is not a clause that has yet been used particularly frequently, but it has been used. There's one case from the early 2000s, which was Lua, R versus Lua, L-U-A-H, and it went to the appellate court in Alberta. Mr. Lua was convicted for trade in an endangered species, and he made about $60,000 in profit through this trade. So on top of the significant fine that the court ordered, the court also ordered that Mr. Lua pay a penalty that was equivalent to the profit that he made through his trade. So other examples up there are that courts can revoke permits and licenses. They can prohibit the use of guns. They can order remediation of harm. This one's pretty common. The accused can be required to publish facts of an offense and their sentence. This works great as a sort of mea culpa, here's what I did wrong, but it also educates the general public about this type of offense. And the accused can also be ordered to notify shareholders of the particular incident and their penalty. And other things the accused can be ordered to do includes environmental monitoring or audits, improving their training, upgrading their facilities. It's pretty much a carte blanche to the extent that the legislation has a final clause in their creative sentencing provisions that says the court can order absolutely anything else it wants that the court thinks would be appropriate in this particular instance. So there's a lot of flexibility there to try and improve the environment, to try and make sure these types of offenses don't happen to again. Now I'm going to turn this over to Alex for a little bit. Do you want to stand? Do you want me to be your Vanna White?
Let me try standing for a bit, and then we'll see what happens.
If you move too far away from this, they'll come back and like move it in front of your face.
If this
I bet.
turns into a disaster, I'll have to sit down again. Okay, so the first act that we're going to have a look at here is the Wild Animal and Plant Protection and Regulation of International Interprovincial Trade Act. I can say that because I've been doing these kinds of files for about 5 years now, and I've had to say it to a court repeatedly over and over again, but we're just going to shorten it to WAPREDA. WAPREDA has two main purposes. The first is that it implements domestically the Convention Against the International Trade in Endangered Species of Wild Fauna and Flora. There are, so far, last time I checked, 183 signatories to this international convention. So as far as international conventions go, it's relatively successful. CITES protects species. There's tens of thousands of species that are protected by CITES, so it's a little hard to come up with any sort of finite list other than referring to the appendixes that they're organized into. So they're organized into 3 appendices. Appendix 1 are those species that are threatened with extinction. So rhinos, cheetahs, manatees, tigers, all sorts of very exotic things. Appendix 2 are animals that are not threatened, but subject to trade practices which could be incompatible with their survival. So I've got a list of some here. We've got bears, iguana, certain types of corals. Remarkably enough, bears are all Appendix 2. So every species of North American bear is Appendix 2. Surprisingly, polar bears did not make the biological cut for Appendix 1. Appendix 3 are those species that are listed on special request of one of the member states, such that they need the assistance of other member states for their protection. The way that the protections actually work is how they interface with the permitting systems for import and export of these animals. So Appendix 1 animals require an export permit from the originating state, and they require an import permit at the state that they're going to. Appendix 2 requires an export permit from the originating state and possibly an import permit at the state of arrival or at the state that it's being traded to, unless the national law requires otherwise. So in Canada, WAPREDA has a provision that exempts exporters bringing an animal to Canada from requiring an import permit if they have an export permit at the country of origin. And then Appendix 3 simply requires an export permit. Now, with respect to live animals, there's another obligation with respect to getting these permits. A person applying for a permit to export a live animal has to demonstrate to the issuing authority that the animal will not be transported in an inhumane or cruel way, and particularly with respect to Appendix 1 animals, it can't be for a commercial purpose, and they also have to satisfy the issuing state that the animal can be cared for on arrival. The second purpose of WAPREDA is that it harmonizes the interprovincial trade or the interprovincial movement of animals provincially. And so that includes animals more than just those that are listed in the convention. It also includes provincially regulated animals. So there's three main sets of offenses that implement the treaty or that enforce the treaty here in Canada. There are various subsections. I've kind of just squeezed them all into the heading of each main section that they appear in. So the first is Section 6. This is going to be the one that we tend to see in all of the international trade cases. So Section 6 under Section 6.1 creates an offense for the importation into Canada of an animal that is taken, possessed, transported, or distributed contrary to the law of a foreign state. And then Section 6.2 creates an offense for the import or export into or from Canada without a permit issued under the Act. What's interesting about Section 6 and 6.1 in particular is that it's based on a predicate offense model. Predicate offenses are not unusual in Canadian law. There's lots of them throughout the criminal code, things like possession of property obtained by crime. The predicate offense is the obtained by crime. The complete offense is the possession of that item that is contraband. So the interesting thing about WAPREDA is that Section 6.1 is premised on this model of a predicate offense, except that the predicate offense is one contrary to foreign law. So essentially what has to be proved in a 6.1 offense is that the animal was imported, but it was also taken in contravention of a foreign state law, which creates some complications that I'm going to talk about looking at one of the cases. Section 7 sub 1 also relies on a predicate offense model for Section 7 sub 2. That's in relation to provincial laws, so animals that have been taken, possessed, distributed or transported contrary to provincial laws. Section 7.1 requires a permit under provincial law. If that hasn't been obtained prior to transport, then a Section 7.1 offense occurs. Section 8 creates offenses for possession of animals inland. And the most significant one that we'll tend to see in the international trade area is going to be possession of an animal imported contrary to the Act. There's a couple of others, possession for the purpose of interprovincial or international transport, and possession of an Appendix 1 species for the purpose of distribution. But both of these are inland offenses. They aren't about the actual movement of the animal across jurisdictions. Okay, so this case is probably my favorite WAPREDA case of all time. There aren't many reported WAPREDA cases, but this is easily my favorite one. So this is R.V. Delisle. This is the BC Court of Appeal decision, 2003 BCCA 196. This decision is actually an appeal with respect to the rule in Kineapple and sentencing. If anybody knows what the rule in Kineapple is, it's the rule against double jeopardy. Mr. Delisle was charged with importing butterflies into Canada. They were an Appendix 1 species, birdwing butterflies. He's an expert in birdwing butterflies and thinks that he's going to go out and acquire 6 of them. These things only live in a particular region of Papua New Guinea. He ends up being charged with offenses both under 6.1 of WAPREDA and 6.2. So 6.1 being importing an animal into Canada contrary to the law of a foreign state, and second, not having the proper import permit. The other great thing about this particular one is just that it's got even kind of sinister facts. Mr. Delisle ends up paying a villager in Papua New Guinea some $30,000, provides him with the chloroform to kill the butterflies and a hollowed out book to put the butterflies in order to ship to Canada. The villager, of course, complies, and the package is intercepted I believe, at the International Mailroom in Vancouver by customs. The one thing about this case is that it actually, if you go to the trial decision isn't reported, but I actually went to the trial decision in order to create a sort of model for some of the work that I do, because in order to prove the Section 6.1 offense, one has to prove that the law of the foreign state was violated. The problem with Canadian law is that it does not permit a trial judge to take judicial notice of most foreign law. There are a couple of exceptions, mostly just relating to the law of Great Britain and imperial statutes. So what someone has to do, and which is what they did in the Delisle case, is they borrowed from principles of conflicts of law, so civil disputes where issues of foreign law are actually engaged. And in those sorts of scenarios, what are required are expert witnesses in the law of the foreign state. So what they did in the Delisle case at the trial level is they actually called a university law professor as an expert witness from a university in Papua New Guinea to testify as to the law and to prove the law, was violated. Mr. Delisle is ultimately convicted of both counts and a total fine of $50,000. The case generally at the BC Court of Appeal level is used extensively for the court's analysis in the rule in Pineapple. So it's got a couple of pretty significant dimensions to it, notwithstanding just the wildlife trafficking dimension. So I used this particular model for this case, and this case is a testament to the great work that Kevin's office does. And the reason I say that is because this was a fairly challenging investigation and prosecution to do, and we only recently, yesterday, got news from the Court of Appeal that leave to appeal by the defendant was denied. So it went to trial in provincial court. There was an appeal to the summary conviction court in Queen's Bench. The appeal was rejected on every ground at the Queen's Bench, and then the defendant made application for an appeal before the Court of Appeal. You got that rejected. So this comes out of actually a fairly extensive international investigation into the conduct of a particular guide and outfitter in Alaska. He'd been being watched for some time by the Alaska Wildlife Troopers, and the troopers are on investigation one day, or an inspection one day, with some U.S. Fish and Wildlife Service officers, and they go to a particular area where this outfitter is working. They're investigating the outfitter for engaging in illegal baiting of bears in Alaska. Brown bears cannot be baited in Alaska, at least at the material time, at any time of year. Black bears could be baited seasonally. So they suspect this outfitter of engaging in illegal baiting. They attend one of the bait sites they think that he uses one day to do an inspection, and it's disused. Nevertheless, they sort of see off in the distance some magpies and other carrion animals, crows and such, circling. So they head over to that area and arrive at what is very obviously a freshly baited site with two recently killed bears. They've been skinned and the carcasses are sitting there. The material that this particular guide uses to bait is dog food and grease, restaurant grease. So anyway, so they see the traces of grease. Ultimately, what ends up happening is they're able to figure out who the clients of this particular guide are on these hunts, because of course they're reporting their kills like they normally would. And one of the clients, in particular, Mr. Clement, ends up getting charged here in Canada for importing his trophy bear, his grizzly bear that he killed at this illegal bait site. So we charged him with Section 6.1. and we charged him with Section 8 for possession of the bear inland. He, of course, brings the CITES controlled animal back for the purposes of mounting. So he's got the hide and the skull. One of the things about this case is it demonstrates how incredibly forensically challenging these things can be. We called all kinds of strange evidence, and it was stuff that you might normally see from a very complicated criminal case, even potentially sort of a murder. There was electronic evidence that was acquired from the accused's phone. Photographs that he had taken at the site with the bear were used in photo comparison to photographs that were taken at the site by the officers. So we had matches of where the carcass was actually sitting. We had biological conservation management experts. So the local area biologist from Haines, Alaska, came to tell us about how they manage the bears and why they engage in such strict measures with respect to baiting. We had Alaskan officers that some of the U.S. officers had actually moved at that point, so we were bringing in witnesses from the southern United States and as far as Alaska to come testify about this material. And of course, in order to prove the law of Alaska, we had to track down a retired judge who came and provided a written opinion. Thankfully, in this particular case, it was agreed to, and the opinion just went in as a report. But in other instances that are related to this overall project, we've actually been calling live witnesses, these retired Superior Court Alaskan judges, to come give evidence about the law of Alaska. This is another significant one, again, that demonstrates the complexity of some of these matters. So this is R.V. Logan. It's unreported. It's from the New Brunswick Provincial Court. But this gentleman was a former RCMP officer who worked in Nunavut. He retired shortly after he worked in Nunavut, but he had made a number of connections with Nunavut hunters and was able to access or acquire narwhal tusks. And so what he started doing when he moved back down south is he started bringing narwhal tusks from Nunavut and actually physically moving them into the United States and selling them to buyers. Over the course of 7 years, he imported over 200 of them, and they were valued anywhere between $1.5 million up to $3 million. He had actually built some hidden compartments into a trailer that he used to drag behind his truck and drive these things across the border. So he created these sort of like long cylinders that were mounted under the trailer, and he would put the narwhal tusks into the cylinders. He was ultimately, there was a fairly lengthy joint investigation with the U.S. Fish and Wildlife Service and Environment Canada, eventually caught up to him. He pled guilty to 7 charges in New Brunswick for a total of $385,000 and a 9-month conditional sentence, as well as forfeiture of the vehicles that he was using to transport the narwhal tusks across the border. Following his conviction in Canada, he was extradited to the U.S., where they ended up convicting him of money laundering charges. What he was doing was he was depositing all the money he was getting in a bank account in Maine, or alternatively just getting his buyers to send him the money in Canada. And then he would come back to Canada and he would withdraw the money from the bank account in Maine using his ATM card. And so that ultimately resulted in another 5-year sentence in the U.S. Okay, so we're going to move away from wildlife trafficking for a moment. We're going to start addressing very briefly the Migratory Birds Convention Act. This is another act that implements an international treaty. It's the Migratory Birds Treaty. As far as I can tell, I haven't been able to find anything else based on some, maybe not particularly thorough research, but this is the first, as far as I can tell, international conservation treaty in history. This is one between the UK and the US. It was signed in 1916. It protects essentially 3 classes of migratory birds. So migratory game birds, so waterfowl and those sorts of things. Migratory non-game birds, and migratory insectivorous birds, so swallows and woodpeckers and things like this, from both hunting, trafficking, and as well as some industrial activity. just kind of an interesting historical artifact, the treaty actually does recognize Aboriginal uses for some migratory non-game birds. So if you ever have a chance to look at this, it's actually a schedule appended to the Act. So if you want to go find the Act and go have a look at the language of the treaty, it's a pretty interesting, like I say, historical artifact. It's a relatively short treaty. The Migratory Birds Convention Act is also the enabling statute for migratory bird, federal migratory bird sanctuaries, as well as federal migratory bird hunting regulations. Because it used to be, it was essentially started as or enacted as a hunting statute. It was only until 2005 that we saw an offense that would apply to pollution. So that's section 5.1. There's two subsections to 5.1, but they don't differ all that much. It's generally the deposit of a substance or a combination of substances that are harmful to migratory birds in an area or waters frequented by migratory birds. So obviously, because it refers both to an area and waters, this sort of pollution offense can be both land and water or ship-based. No discussion about the Migratory Birds Convention Act is complete without referring to Syncrude. And most of the people in the room may actually know this case relatively well at this point. But this was a case that received a lot of international attention. Even it was a 9-week trial that was held in St. Albert in 2010. And it relates to, in 2008, an offense under Section 5.1 of the Migratory Birds Convention Act for essentially permitting 1,600 migratory birds and some other ones that are regulated under the provincial legislation to land on Syncrude's Aurora bitumen tailings pond, which is a massive deposit area for bitumen tailings up near Fort Mac. It was about 17 hectares, or the size of 640 football fields. The pond had opened in 2000, but the oil and gas industry had been well aware of the risks involving open bitumen storage facilities since the 1970s, and there had been some work that was done in that. Typically, what Syncrude did is it would deploy these deterrent sound cannons, so these propane-powered cannons that make a noise to scare birds away from the pond. The pond appears to be a very large, attractive place for birds to land when they want to hang out and swim and forage for food and that sort of thing. Because the pond is so massive, the cannons they have to deploy are on fairly regular intervals, 250 meters along the shoreline and 500 meters apart on the actual surface of the pond. Syncrude's written policy on the deployment of these deterrents recognized that the birds would start to come conservatively in March, mid-March. So I had to get them out by March 15th. And that year they simply did not deploy them. They just didn't put them out. The great thing about the Syncrude case is if you're a novice to regulatory crime, the complete decision actually reads a little bit like a handbook on regulatory offenses. It starts with a description of characterization of the offenses and the principles of offenses as strict liability, and then quite literally goes through just about every doctrinal defense that could possibly be raised with respect to one of these kinds of cases. So it does a fairly thorough due diligence analysis. It deals with officially induced error, as Aaron mentioned. It deals with abuse of process, which is something we sometimes see in regulatory offenses. It deals with de minimis, de minimis non curat lex. The law doesn't concern itself with trivialities. Even that defense was raised, notwithstanding the fact that there were 1,600 birds that were killed. The penalty to date is still one of the highest historical penalties for an environmental offense in Canada, at least under the Migratory Birds Convention Act. It is now still the case, even with the changes in the legislation. This was done under the old Act in terms of this sentence. They were charged both under the Migratory Birds Convention Act and Section 155 of the Provincial Environmental Protection Enhancement Act, which is an offense for storing a hazardous substance in a way that it might directly or indirectly come into contact with wildlife. The penalty was in the neighborhood of $3 million, and it was a mixture of both a straight fine and a creative sentencing penalty. They both had to revise their waterfowl protection program within 90 days of sentencing, submit it for approval to the province of Alberta, and then contribute some monies to some other things, such as a program for bird deterrence and a good deal of money for the purposes of purchasing land for what was a migratory bird sanctuary. All right, I think that's you.
Quick switch, we're going to look at the Species at Risk Act and the Fisheries Act. So first, the Species at Risk Act has offenses for Canadian species that are listed under the Act as threatened, endangered, and extirpated. So all the species that are covered under the Act are listed in schedules to the Act. And there's a federal committee. This committee is called the Committee on the Status of Endangered Wildlife in Canada. And that committee reviews and makes recommendations to the Minister of Environment and Climate Change Canada on what species should be listed under the Act. So that list has been growing over the last several years. Within SARA, I'll refer to SARA, Species at Risk Act, there are several different types of offenses. There's an offense for killing, harming, or harassing or taking a listed species. There's offenses for possessing or trading listed species. And then there's also some offenses related to species habitat protection. There's an offense for damaging the residence of a listed species. And then there's an offense for destroying critical habitat of a listed aquatic or migratory bird species on federal lands. To date, critical habitat has been designated for approximately 15 species under the Act, and they're all fish and whale species. All but 2 of these species were designated in 2016 and 2017. So this is sort of a newer part of the Act that's coming into force. And as of yet, we have no convictions under the Species at Risk Act for destroying critical habitat. There's approximately 12 convictions under the Species at Risk Act across Canada since it was enacted in 2002. This is a fairly low number compared to other pieces of federal legislation, and there is only 1 conviction under the Species at Risk Act against a corporate offender, and that case is R versus Canaport Limited. It's a New Brunswick provincial court decision from 2015, and it's an unreported decision. Canaport is a natural gas provider. It had a compressor to maintain safe levels in some gas storage tanks. The compressor had a mechanical failure, so for a period of time, in order to reduce the pressure on these gas storage tanks, Canaport had to start using a flare stack. And this flare stack ended up killing thousands of migratory birds due to the heat. 4 of the migratory birds were Canada warblers, and they are listed as a threatened species under the Species at Risk Act. Canaport pled guilty, and they were fined $100,000 or $25,000 a bird for those 4 Canada warblers. The money, about 75% of that fine, went to further protection and conservation of Canada warblers. There was an initiative. Another interesting case under the Species at Risk Act is R versus Pak Sun Chung. It's from Ontario. Again, it's an unreported case. It's from 2009. Mr. Chung captured 26 Blandings turtles, and Blandings turtles are threatened under the Act, and 1 spotted turtle, which was endangered. Environment Canada was able to release the Blandings turtles back into the environment, but they weren't sure how well they would survive due to the poor condition of the turtles. And the 1 endangered turtle ended up dying. Because it's unreported, there's not a ton of facts around what I've been able to find out about Mr. Chung's offense, but it appears that he was catching the turtles to sell them for consumption. He ended up pleading guilty. He was sentenced to 9 months in jail and a 3-year probation period. This is a fairly stiff sentence in an environmental offense for an individual to receive 9 months real jail. I'm uncertain, but I suspect that Mr. Chung likely had previous convictions for dealing with endangered species or trade of species in order to get such a stiff fine. The last case that's listed there is R versus Lake Louise Ski Area. It's a case that's currently before the courts under the Species at Risk Act and the Canada National Parks Act. In December, Lake Louise Ski pled guilty to cutting trees in Banff National Park, including the endangered whitebark pine. This case involves a larger number of a harm species than any previous SARA case, and the sentencing hearing is set for July in Calgary. So the last act we're going to look at is the Fisheries Act. The Fisheries Act is the oldest environmental piece of legislation in Canada's history. It was created in 1867 and has gone through many amendments since then. So fish is defined in the Act to include shellfish, crustaceans, marine mammals, and all life stages of fish. There are two main provisions in the Act, and there's a typo here. That should say Section 35(1) and not Section 35(2). But that provision makes it an offense to carry on any work, undertaking, or activity that harms fish habitat. Parliament is currently in the process of amending the wording of what it means to harm fish habitat. It's gone through several iterations in the last couple of years. And the second primary offense under the Fisheries Act is Section 36(3). That's an offense to permit the deposit of a deleterious substance into water frequented by fish. It's kind of a two-part offense. There's also an offense to deposit a deleterious substance in any location where it may reach water frequented by fish. So there's, it either goes in, and that's part of the first part of the offense, or it may go in as a second part of the offense. So it's actually an example of, and it's a rare example in federal environmental legislation, of the precautionary principle being used as part of an offense. For the interest of time, I won't go through this, but there's a few other Fisheries Act offenses that are less well used, and you can see them on the slide. I do have an example of a case under the Fisheries Act. Because this has been around since 1867, there's lots of offenses under the Fisheries Act. But this is a recent case. It's from Alberta, and it's the Obed Mountain Mine. It involved offenses under both Section 35 and Section 36 of the Fisheries Act. Obed Mountain Mine is a coal mine. It was run at the time by Coal Valley Resources, Inc., or CVRI. The mine has a massive settling pond, or had a massive settling pond on its site, and the dike on the settling pond failed. It ended up in 670 million liters of water and 90,000 tons of sediment being released. So to give you an idea of size, 670 million liters is the equivalent to 268 Olympic-sized swimming pools. It was one of the biggest releases of a deleterious substance in Canada's history, followed shortly thereafter by about a year by Mount Polly in BC. The release destroyed 4 to 5 kilometers of fish habitat in a creek, and then it impacted an additional 17 kilometers downstream in that creek. There was also a plume that was created downstream in the Athabasca River, and this plume had total suspended solid levels that were above what is appropriate for fish, what is safe for fish, and this plume went for approximately 400 kilometers at those high total suspended levels down the Athabasca River. No dead fish were actually found as a result of the incident, but fish would have died as a result of the huge impact of the sediment and water in the small creek. The sentence on that one was under the old $300,000 maximum per day fine provisions, but the sentence exceeded that maximum by using the creative sentence portions of the Fisheries Act. It's a multi-part sentence. The total was a $3.5 million monetary penalty, and that penalty was split between the 35-1 and the 36-3 charges. $200,000 of it was paid as a fine. $1.65 million went to the Environmental Damages Fund for fish and fish habitat conservation. An additional $500,000 went to the Environmental Damages Fund for fish habitat restoration that was particular to the East Slopes area of Alberta. And then the last part of the penalty was $1.5 million, which went to a trust fund at the University of Alberta to do research into effective fish habitat restoration. The second part of the sentence was rehabilitation of 5 kilometers of the creek. And the third part of the sentence was $615,000 that had to be paid in compensation to Fisheries and Oceans Canada. And that amount was for the cost that Fisheries and Oceans Canada expended on hiring a geofluvio-morphologist company, so a company with expertise in creating a rehabilitation plan for the actual creek. There was an additional provincial charge against the mine under the Environmental Protection and Enhancement Act in Alberta for significant adverse harm, and that received a $925,000 fine on top of the $3.5 million. Do you want to briefly address this? And we have one last slide with a couple of issues that Alex and I have seen come out of some of these types of cases.
So one of the things that definitely comes out of any of these kind of cases is the challenges in terms of their proof. The first bullet, of course, says that it's difficult to prove deleterious substances under Fisheries Act or Migratory Birds Convention Act offenses in remote areas where typically what will happen is the officers on the federal side sometimes don't hear about maybe the second to hear about the offenses and show up a couple days late. And there's no evidence left in the field in terms of that critical element of the offense. The same would go for hunting-based offenses as well. Often you'll arrive in the field and simply just arrive at a kill site and have nothing to work from other than what's immediately in the field. You don't know who was there, etc. Wildlife trafficking offenses are also relatively amenable to environmental fraud, which makes them difficult to detect. And so one of the things what I mean by this is that when you're out in the bushes, left to your own devices, it's easy to sort of cover it up using proper paperwork. So we will see people who have gone out and obtained all the CITES permits they need. And inspection at the time of entry into Canada with respect to those other underlying elements, whether the thing was taken in contravention or transported or distributed in contravention of foreign state law, can't really be inquired into at that point. Interjurisdictional cooperation. So whether we're talking about the regional level, so within Alberta, interprovincially, or whether we're talking about international investigations, frequently what we see with these kinds of files is that there are multiple agencies involved, all with different mandates and all with different approaches or even legal authorities, particularly when you get into the area of international investigations. It's both a blessing and a curse. On the one hand, we can rely on the resources of multiple agencies. On the other hand, it can be fairly challenging in terms of coordinating how evidence is acquired, how we're entering it into court, the authorities under which it's acquired, because those may differ between agencies. And again, evidence can be acquired from multiple jurisdictions spanning wide geographic areas. I've brought a witness as far away from Africa, simply because he was transferred out there for his next posting. So these things can get complicated and they can get resource intensive. And then finally, they can be forensically very challenging because they invoke wide varieties of expert evidence. So I've talked a bit about experts in foreign law. Aaron has talked about experts in economic use and non-use evaluations, which is challenging, which is, I don't know if it's science or soft science, or I don't know what we want to call it, but it can be fairly challenging kinds of things to assess. And I think sort of given all of these sorts of issues, particularly when we couple that with the fact that these things are simply difficult to prove and difficult to detect, when we couple that with the message that Parliament is sending us now with our new updated penalty provisions, mandatory minimums, significantly high ranges, we're essentially getting the message that these kinds of crimes need to be prosecuted with a relative degree of rigor. So I think that
We've had
concludes.
cases that have 4 or 5 expert witnesses in one trial, so they can get complicated.
Yeah, and frequently we even need to run them in tandem. I mean, we can't prove one element of our case without having a couple people testify in expert areas, one after the other, on top of each other. So an example for it might be the particular characteristics of oil is required for somebody to testify as to how toxic it is, right? So they need to know what kind of oil it is before they can testify as to what toxicity it is. So you get into these kind of strange constellations of evidence. So we'll leave the floor to Kevin.
You need to switch. We'll use the non-technologically advanced lawyer to try and help you, which is probably a bad idea. Martin, where are you? How do we find Kevin's PowerPoint?
On the desktop.
I know.
Real desktop.
It's not a real desktop. I'm a technological peasant.
That's awesome. And I should say, I think the idea was initially that we would take questions, but I think we'll have the panel together and then we'll just do a round of questions. I think in light of time and everything like that, we'll just do all the questions at one time.
Good morning. Recognizing the time indications, I'll try and be a little bit quicker, so I'll be around for questions afterwards because I'll go through my slides relatively rapidly. Wouldn't you know it, the day that you have to present, you obviously end up with a sore throat, so hopefully I don't cough or anything like that throughout the presentation. I did bring a number of exhibits with me, and those was basically time fillers just in case I went a little too quickly, so I will use a few of them though.
Do you want help, Kevin?
No, I'm okay. I want to start off with this one. What simply appears to be a chunk, well, ones would actually say it's a rock. Actually, this is a piece of black rhino horn. Its current valuation, somewhere around, I'm guessing here, $50,000 to $80,000 for this small piece of rock, or actually fingernail, if you think of it properly. Black rhino, 96% decline in population from 1970 to 1995. So there were 70,000 black rhinos out there in 1970. In 1995, there was 2,410. I'm not exactly sure of the number now, but you can imagine that's a substantial decline in black rhinos. Rhino overall has a 4.5% 4.5% reproduction rate currently, and is an 8% death rate right now. So the trend is downward. There are over 1,000 rhinos killed per year in South Africa. And I think there's currently around 12,000 left. So not a heck of a lot out there. I was going to bring an elephant tusk, but it's about this long and about 40 to 50 pounds, and I didn't feel like packing it through the snow this morning, so I went with the smaller piece. So what I'm going to do with this presentation is actually talk a little bit about, it's just going to be a glimpse. I can't get into it in depth because there's actually so much to talk about. A lot of the photos that you're going to see on the presentation, they will be actual photos of exhibits that we've seized through Environment Canada. So I will try and speak to them briefly as well. I have a number of exhibits too. I'll probably only be very selective on pulling them out in the interest of time. So just into a glimpse on what I'm going to talk about is essentially exploration on what is the problem, we're going to look a little bit into the why. Why is this important? We're going to talk a bit about the effects and also, in the end, more on what we are doing about it. So I'm also going to introduce the Canadian element to it. Like we talk about elephant ivory, and I do have elephant ivory here, but I'm not going to bring it out. But what happens when the elephants are all gone? Where do we turn? Walrus ivory. We move to the next point. If people want ivory and the elephants are all gone, this is the next target. That's Canadian. That affects us. So we have to be cognizant that this is international. When we think wildlife crime, wildlife trafficking, we're always thinking Africa, we're thinking Asia. We have to stop thinking that way. We have to start thinking internationally, including Canada, North America, Mexico, United States. We have to think about that. So what is the scope of the problem? So currently wildlife crime is ranked 4th in terms of highest grossing illegal activities. You have your drugs, your illegal money, your counterfeiting, your human trafficking, and somewhere in there, I'm not sure exactly what the numbers are now, guns are in there as well, the trafficking in guns, and then you have wildlife crime. So we're consistently usually about 4th. So you can see animal, plants, and timber are about 155 billion US dollars a year, and drugs are 200 billion US dollars a year, so we're not far behind. United Nations reports that environment crime is rising at a rate of 5% to 7% per year, which is double world economic growth. And, as I'm going to speak about in this presentation, it's a threat to Canada's domestic and international and foreign interests. Interesting to note that Aaron did speak briefly about turtles there. Just to note the linkages between wildlife crime and drug smuggling, in Canada and Toronto, we actually encounter that quite a bit, in which, such as Asian triads, they do, like, in terms of their drug smuggling, also do like live turtles and like to serve as a soup their live turtles. So there is that linkage, and we are seeing that linkage quite often. So this is an Environment Canada intelligence analysis, taking a look at the money, looking at drugs versus wildlife. The green represents wildlife, the blue represents drugs. So you can actually see right now a gyrfalcon, a live gyrfalcon, is worth $330,000. This is maybe about a year ago. Right next to it, heroin, in pounds per kilogram, $142,000. It's quite a significant jump. And you can see out of the top, a lot of them are actually wildlife. Of interesting to note on this particular slide, bringing back to Canada, there's 4 Canadian items that we have on this list that actually represent significant dollar values. This is gyrfalcon, right at number 1. Polar bear is on this list. Black bear bile, and I actually have some bile with me today, is on the list. And narwhal, which we talked about Alex talked about in R versus Logan. So there's 4 Canadian species in all those greens there. Again, we have to be cognizant of Canada. So what is driving this? Well, we have seen a significant economic growth in Asia. And we're linking that back to significant economic changes in terms of wildlife crime. Let's explore the why. Why wildlife crime? We can always speak about the money. People understand money, but what are the uses? And I've got 4 slides on that. And these are things I come up with myself and things I looked at in terms of terming them myself, but in how I've seen it over in my experience over the number of years. Notoriety. The more dangerous the animal, the more some people want it. For example, there's been anecdotal evidence about some biker gangs. They like to have venomous snakes. It proves how bad they are. So obviously, they want to bring those venomous snakes. Where are most venomous snakes? Not mostly in Canada, they're mostly in southern US and South America and Australia. Some people want to show it, indicate what lengths they'll go to get an animal product. They want to show it off. They want to show how important they are and what kind of connections they have. It's basically something that sits on the wall. There's the interest aspect of it. And you'll see there, those are photos of narwhal tusk. I was going to speak about the Logan case briefly, but Alex so successfully did that. So in terms of special scientific interest, some people have a scientific interest. They want these things like rare butterflies in order to study them. But they may not be associated with any organization, so they might try to get them illegally. Visual appeal. Something looks really, really interesting. I have in the bag here a carving out of an elephant tusk. It's actually beautiful. I brought it home the other day, put it on a desk because I had to glue a piece on that I broke. Sorry. But my wife actually said it's beautiful. It's actually beautiful until I told her what it was worth and what it was out of. It was a full-size carving. So again, the need to have it to show it off. It's unique and no one else has it. And that brings us even into the tourist aspect, where people will go down and they'll see things and they'll say, well, that's really kind of cool. They'll be in South America or Central America and they'll buy it, thinking that it's kind of cool to show off to their friends, not realizing that it's putting those animals at risk, and not realizing it could be a WAPRETA violation or a CITES issue. Things like a belt. I have things with me actually, a wallet made out of cheetah hide, a sea turtle bracelet, and I also have a cobra belt. So that's important as the tourists as well. We have to think that we're contributing, even though we don't intend to do trafficking, we're also all contributing when we go and potentially buy these things. So we encourage people, we have exhibits in airports, to think twice before you buy certain things. Traditional foods. Customary practices hold strong no matter location, and I won't try and pronounce the Latin. There is no accounting for taste. The pictures that you see here, the first one's to, I guess would be your left. That's actually barbecued goat head, and in the center and in the bottom there is actually some primate ribs. These were actually intercepted, I think it was Toronto, and actually came into a case in which someone returning from Cameroon wanted their traditional food. To them, this was food. To us, it may be something totally different, but to them it's food, so they put it in their luggage and they brought it back. And this is what customs intercepted for us. By the time, of course, it got here, it was full of maggots, but we also have to be concerned about other things, like what diseases are coming, what pathogens are coming with these particular animals. Traditional foods, on the side there's a queen conch shell. Now, queen conch is the shell you hold up to your ear when you're on the beach and you want to hear the ocean. That's the shell you traditionally use. Now, Operation Shell Game, which went between Environment Canada project, we call it Operation Shell Game, between 2006 and 2010, we investigated queen conch meat coming north into Canada and the United States. It was a joint investigation with the U.S. Fish and Wildlife Service. And that investigation resulted simply from someone had mislabeled a product coming to the country, and one very astute investigator, inspector, looked at it and said, that doesn't look like what you're saying it is. And we basically overturned the cart. We found so much that came into Canada and the US, where Asian expats and Caribbean expats wanted them in their new places of residences for food. Interesting to note that they were using the same methods to smuggle the queen conch meat as drugs did. Same methods, same routes. Also interesting to note, between 2006 and 2010, we seized 27 tons of conch meat. Now, we did the calculations, and that 27 tons approximately represents 5% of the total conch meat biomass that exists in the Caribbean, was in warehouses in Canada and the US, and eventually ended up getting destroyed. Traditional medicines. We're all quite familiar with Asian traditional medicines. On your right-hand side there, you'll see rhino horn. We talked about rhino horn as well. It is an Asian medicine. There are allegations it cures cancers, helps with hangovers. It's an aphrodisiac, lowers fevers, helps with rheumatism. In 2008 or 2009, allegedly a senior Vietnamese politician came out and said, I used this and it cured my cancer. And that made a huge run on rhino horn. In fact, the horn I'm pretty sure it's that horn on the right there that you see, was offered for sale in a Vancouver auction house. They expected to bring $20,000. There was a huge bidding war that erupted between 4 Asian bidders, and it ended up bringing $223,000, that horn alone. Let's bring the Canadian aspect back into it. That's a ginseng root on your left there. Ginseng grows in Canada, and actually there are places in Canada where it's being illegally harvested and smuggled out of the country and going south and into the Asian markets. Ginseng has a lot of traditional benefits in terms of what people believe. The interesting thing about ginseng is the more it has certain characteristics, the more it can be used as a lucky charm, and essentially what some Asian medicine persons use it for is to put it on a shelf like that as a lucky charm in case they ever get sick. Now the price can vary quite a bit. It's often approaches many thousands of dollars for one root. This root would be extremely expensive, given the fact that if you can see, and I'm sorry it's maybe a little distant, you can see it somewhat resembles a human in terms of the head and the arms and the legs, making it, that's probably why it's in the box and being used as a lucky charm. So again, the Canadian aspect of it, it's actually has been smuggled in Canada, and we've actually had cases on it. I spoke earlier about bear bile as well, Canadian aspect to it. Bear bile is another medicine that's has apparent or alleged medical effects, unproven of course, but nevertheless, Canadian born. Status symbols. There's the expectation, such as shark fin soup, served at weddings in, can't remember East Asia. I can't remember the exact country. It apparently improves the consistency, but there's expectation that it's going to be served as a wedding soup. Quality of the product. We're talking about caviar. We all heard the term caviar for the rich. There's a lot of fish that are being basically going towards the threatening stage because of caviar. Texture of material. This right here is a scarf. It's from the Tibetan antelope. It's called a shaw tooth. And the reason it's called a shaw tooth, in Persian that means king of wolves. It's extremely soft. It's the one some people may have seen where you can thread it, the scarf, right through a wedding ring. And it's very highly prized. It's coming back and takes 3 to 5 individuals to make one shawl. This is likely valued in the $5,000 range right now. So people actually do want that. It's extremely soft, extremely nice. In terms of other things people want, like you've all seen the alligator boots, the sea turtle shoes. Those things are things that people will pick up south thinking that's a sign of status. The picture here actually is, you'd be surprised to see a guitar there. It's actually made out of Brazilian rosewood, which is of course out of Brazil. And there are implications towards CITES on Brazilian rosewood. So the other side of hunting. Hunting obviously has it's something that's done a lot throughout the world. A lot of generations it's been passed down through. There's a lot of interest in hunting. It can be associated to hunting. The global economy has changed it so that hunting, people can travel anywhere. It's not like in the British monarchy in the old days where they had to travel by boat for 3 months to get to hunt the Bengal tiger. It's 20 hours in an airplane, you're there. And there's new wealth in various markets throughout the world that make hunting easier. And people do want bragging rights. The photo to your right there is actually, I don't think it's the Logan bear. Alex talked about R versus Logan, but it's one of the bears associated in that file. Actually, 17 individuals were charged within that file. Or it was Clement, sorry. Clement. 16 other individuals were charged during that event. So this picture here, see other things as well. Canada in the Rough was a show in which showed hunting interest across Canada, and it was watched by a number of people, obviously. And of course, you didn't see the other side of some things that happened. You see the legitimate chase, legitimate hunt, legitimate kill, but you didn't see the other things, such as they were using vehicles to herd muskox. They were hunting muskox and wood bison. So they were using vehicles to herd them. They were using skidoos to herd them. They were getting too close. The laws in the north require a certain distance before you actually have to get out on your foot and hunt them. They were using vehicles too close. You don't see that stuff. That was all edited out of the footage. What you see is the footage of what seems to be a legitimate hunt, but it was not in this case. So Canada in the Rough actually was convicted. This gentleman was actually convicted. So this is the what are the effects. So quickly evolving demand, organized crime is involved, so benefits of organized crime, they're making money. Corruption, just speaking about corruption, make the linkages. Wildlife is regulated most everywhere in the world. Corruption is one link in the chain that allows illegal goods through. When those illegal goods get through because of corruption, public has less confidence in their laws, which leads to a developmental security issue. So you can see that chain of events just impacted by wildlife trafficking. Organized crime against a very limited enforcement capacity, and our rangers in Africa, for example, are armed with old British 303s, and the poachers have submachine guns. So there's a difference in ability here. It's an environmental issue. Habitats change. Loss of biodiversity. There's a loss of species. There's human-wildlife conflict. As we pressure ourselves down to certain areas, the wildlife and humans they want the same areas, so that conflict occurs. Diseases, climate change can all be linked to change as an environmental issue to wildlife trafficking. It's also, I'm very cognizant of time, so I'm going through relatively quickly, a sustainable development issue. Loss of revenue. Tourism is a major source of income for a lot of African countries. Local communities often suffer. You have to realize wildlife crime mostly happens where wildlife exists. So it's usually in locally small communities, and those communities, often it's their only source of income. So this crime does hurt them in terms of wildlife crime versus sustainable harvest. Just a link to Canada again, that's a polar bear skull, in case you're interested. It's a Canadian trade issue. 100,000 jobs are linked to wildlife trade. Iconic Canadian species, corruption again. One of the things we have to look at, take a quick look at forestry. There's not the same rule of law in many countries. For example, forestry crime. Illegal harvest is estimated to represent 8 to 10% of wood imports into Canada. If you do the numbers, that actually turns out to represent about $1.5 billion. Again, using the numbers game, that represents 13,000 direct or indirect jobs that are lost in Canada as illegal wood undercuts the market. And that creates an uneven playing field in Canada as compared to the rest of the world. So what is being done? The London Conference was called by the Prince of Wales, in 2014, included 46 countries and 11 international organizations. And the A through D there are some pretty powerful statements. Eradicating the market for illegal wildlife products. That's going back to the why earlier in my presentation. Getting rid of the why people want this. Ensuring effective legal frameworks and deterrents. That is where the legal community comes in. That's where we have to do the right job to make sure that the laws are strong, they're robust, and they're well used. Strengthening law enforcement, making sure the capacity is out there, whether it's in Canada, internationally, make sure the capacity is there. And recognizing that legal wildlife harvest sustains livelihoods and is part of economic development. So other efforts. CITES, Alex mentioned that. There's currently 5,800 species of animals and about 30,000 species of plants on the Convention on International Trade Endangered Species. There's a number of resolutions. It's involved in G7, G20 summits. Other initiatives, the USA has a national strategy for combating wildlife crime. Europe has something similar. Other countries do as well. A lot of work is being done in terms of on these resolutions. So Canadian efforts. Obviously domestic engagement. Alex talked briefly, and Aaron did as well, about working with our partners, provincially, federally, making sure departments are working together. International engagement, making sure we're working with the U.S. Fish and Wildlife Service, other countries who have an interest. Our international engagement in CITES, we're very much engaged in Interpol. Sheldon Jordan, who was pictured beside the bear in the earlier photo, is actually Director General of Wildlife Enforcement. And he is actually the past chair for the Wildlife Crimes Working Group out of Interpol. Carolyn Caceres from the Canadian Wildlife Service is the current chair of the CITES Standing Committee. And of course, the bottom line there is actively participating in international files. We need the capacity to make sure that we are, when the U.S. Fish and Wildlife Service country calls us, when other countries call us, that we are actively participating in those international files. And just a quick annex on upcoming events. You can see a whole list of events there. Just drawing your attention, July 16th to 18th, the Montreal conference. Actually, wildlife is listed on the agenda at that conference. So I apologize for going relatively rapidly, but it's my presentation. Thank you.
Okay, so what we're going to do, I think, because we have time between this panel and the next one, we'll have some questions and we might go a little bit over, and I think that's okay, a couple minutes. I'm going to take my prerogative as the moderator, and I'm going to kick off with a couple of questions that I have, and then in the meantime, I will either be accepting online comments or else Nancy will be walking around the room with microphones, and you can ask her a question that way, put up your hand, and we'll just kind of pick you out. So, for my part, Aaron and Alex, thank you for going through some of those cases. I guess two things that I wanted to sort of talk about, or I wanted to ask you about. One is, I couldn't help but note that so many times, and this has certainly been my experience doing research in this area, unreported cases. So here's an unreported case, here's an unreported case. So my first question is just like, what is going on with unreported cases? Why does that seem to be such a convention? Because it really does, I think, from a perspective of the jurisprudence and developing the case law and stuff like that, it obviously is problematic. The other one I just want to talk about also, I get some sense about, you mentioned that DFO got a big chunk of the Obed mine fine amount for cost recovery with respect to the gathering and analysis of evidence. And it seems to me like that's a really big win. And I'm not aware, though, that was common in the past. And so I'm just wondering if you could speak to whether or not that is something that happens, because, of course, from the perspective of prosecuting these cases, one of the things that we'll talk about tomorrow is AMPs and alternative approaches to enforcement. And when enforcement costs a lot of money that's not recoverable, then I think it provides a disincentive for departments. So I was wondering if you could just speak a little bit to that side as well.
Okay.
And you will have to come up here, unfortunately.
Come up there.
It is, and the
Yeah.
camera can move?
Okay. I'm not even gonna tap it. Tell me if you can't hear me. I can address both of those fairly briefly. With respect to unreported cases, a lot of environmental offenses end up in guilty pleas. And when they end up in guilty pleas, those sentences are often not reported because there's no written decision by the judge, there's no transcript. It's generally the more contentious where you actually have a sentencing hearing, where there's both sides that are fighting about what the penalty should be, where you may end up with a transcript and a reported sentence. A lot of our sentences are joint submissions between the prosecutor and the defense counsel. We agree on what we think is the appropriate penalty, and we pitch that to the judge, and then the judge makes the final decision. As a result, a lot of those cases don't get reported. There's no real decision that's written on it. So that's I think, the key reason. With respect to the Obed case and the extra penalty for paying DFO for the cost of the experts that they hired to create a remediation plan, those sorts of clauses have existed in sentences in the past, but not particularly frequently.
So I guess I'll open it up to the room now. So,
Hello? Okay. Thanks so much for the presentation. Aaron, you started off talking about the sentencing regime that applies to most of the statutes. I was just wanting to get your take on whether that regime is working well in terms of accomplishing the purposes of sentencing. Are there roadblocks in the legislation to getting better sentences, or are there roadblocks somewhere else in the process?
It's pretty early to tell because there haven't been that many cases yet to see what sort of impact it's having on a larger deterrent aspect. Definitely, we are running more things to trial now where we used to have pleas because there's a larger jeopardy, and so offenders are willing to fight this as opposed to rolling over and pleading guilty. It definitely makes more sense from my perspective when I used to have sentences against very, very large corporations, and my maximum penalty I had to deal with was $30,000, and this company's making billions and billions of dollars a year. It was really hard to create a sentence, even under the creative sentence provisions, that was going to have a deterrent effect on such a big company. So I think that the potential for the larger penalties also allows for a larger deterrent value when you're dealing with larger corporations. And we need to use those creative sentence provisions more often.
so we'll have one in the back there, and then Jeff, and then I think we'll have to call it at that.
Okay, I have a question for both parties. Just in terms of ginseng, I'm assuming that's wild ginseng because there is ginseng farming occurring in southern Ontario. And the other one is, would you argue that the release of deleterious substances from stormwater outfalls or raw sewage could fall under the Fisheries Act?
For the ginseng, yes, that is wild ginseng in southern Ontario and southern Quebec as well.
Yeah, in terms of raw sewage, yes, it does fall under the Fisheries Act. It's actually currently also managed by the new wastewater effluent regulations that were made under the Fisheries Act. But yeah, an unauthorized release will be a Section 36 sub 3 offense.
And we've had those prosecutions and convictions in Alberta. Yeah, there have also been convictions for releases down storm drains, storm sewers. There's a conviction just last year against Canadian National Railway when they released diesel fuel that went down a storm sewer and into the North Saskatchewan River.
I've got a question for Kevin. Guitars and musical instruments, if there's a lot of instruments manufactured before Brazilian rosewood and ivory became protected substances, what if you're traveling across an international border with something that was made previously? Is there a risk things would be seized?
You're right. The Convention on International Trade in Endangered Species was 1970, I believe. So we do refer to things as pre-convention which means that they may be legal for possession, may be legal for travel, etc. There are certain requirements that you have to meet that pre-convention. You have to be able to prove it effectively under the law. And we look at various factors when we actually are looking at that. You even have concerns about a lot of people bring pianos into the country. Well, back in the 60s, everybody wanted an ivory key piano because it showed your status. And now they're still out there quite a bit, and you see people moving across borders, and they've got to prove that that's pre-convention. So yes, there are rules around it.
Kevin, I'm shocked really at the numbers that you put out about the financial scale of the illegal wildlife trade, $155 billion annually worldwide. I'm just wondering, though, maybe I couldn't read it from back here. What portion of that, or are you able to give us some indication of what portion of that would be Canada's share, I suppose? So that's the first part of the question. And the other part of my question really is, of course, over the years, we're all familiar with the war on drugs and the war on a variety of other kinds of activities. I'm just wondering if you'd make some comments about the level of response, I suppose, to the scale of this illegal wildlife trade, because to me it seems as though we're not seeing or hearing too much about a war on the wildlife trade or illegal wildlife trade.
Okay, thank you. Canada's share, I'm not really sure actually, because I'm not an economic expert for one thing. I imagine those numbers do exist out there. It's just a matter of pulling them up and finding that economic side. When we do look at various things in terms of a sentencing, et cetera, we will try and value animals to find out what is the valuation of it for appropriate sentencing. So we do get a little bit into that area, but not incredibly deep. In terms of the scale of trade, you don't know what you don't know. So if there's a lot of legal things going out there and we don't know about it, obviously we can't really give a number on it. So I imagine the things that we don't know, you do know, you have to sort of say, okay, if we know that much, there's probably this much we don't know. So that's essentially how I'd have to answer that one, because there are things we have to do. And in terms of our capacity, if you don't know a lot of things, how do you set your capacity to meet those things? So as we begin to learn more and more, we have to strengthen our resources. We have to work better with the prosecution service to make sure stronger deterrents are placed, to ensure that people aren't going into this area of crime. So our capacity has to meet the need, and obviously there's a whole bunch of economic factors such as budget, taxes, everything that have to play into that. But your capacity, you have to look at the ability to protect the resource and make sure there's adequate deterrents in place. Are we there? I don't think we'll ever be there, because if it's continuing to increase over time, we are playing the catch-up game.
So somewhere Donald Rumsfeld is feeling very vindicated, I think, on that point of the known unknowns and the unknown unknowns. So we're going to take one last question. I know there's lots of questions. There's questions online. I apologize. We can't get to all of them. We do have a full program today, and I think it's important that people do get 10 minutes between this session and the next one to sort of stretch the legs and maybe grab a beverage, coffee. So we'll just take one last question. Okay, thanks.
Thanks very much for letting me squeeze in this one last question. And I'm really learning a lot about wildlife enforcement, et cetera, so thank you. My question is, how effective do you think fines are in preventing repeat offenses? An example is the individual who was a repeat offense in, what was he bringing, 250 narwhal, was it horns? Yeah.
The narwhal tusks.
Tusks, yeah. So I'm wondering about the fines, the effectiveness of the fines overall.
Who wants to take this?
Yeah, I mean, I suppose it sort of does go back to, the first question of, how effective are fines generally as deterrents. In the case of Mr. Logan, he was doing it over a long period of time. It's not like we caught him once and then convicted him and then caught him a second time. yeah, unfortunately, I mean, we don't really have any data to be able to determine just how effective it is. But I can say one thing. Certainly, and I don't think I'm telling tales out of school here, but certainly after the Syncrude prosecution and the amount of publicity that got, I think we definitely did see, at least for a little while, a change in attitude from corporate offenders generally. And there was a real concern about going to trial, about the negative publicity that might attract, and that sort of thing. And I think, I imagine that also, I mean, that was what we were seeing in terms of dealing with them directly in our work. But I suspect that would also convert to doing things a little bit more cautiously throughout their operations. But I mean, that's just me engaging in some guesswork.
And I think there's so many reasons why a fine may be a deterrent for one person and not for another person. There's so many factors that get involved. I mean, I had a young man who illegally brought things into Canada and ended up with a significant fine that he's been paying off for years and years and years, and I don't think he'll ever do anything like this again. Yet you have Mr. Chung, who had the Blandings turtles and is probably turning a profit over this, and that's why you see him getting jail, because fine hadn't been a good deterrent in the past. So there's a lot of factors as to whether a fine is going to be a deterrent for any particular offender.
Okay, well, if everyone could just join me thanking the panel one more time. And we'll be reconvening at 10 to 11.